City of Stevens Point Board of Zoning Appeals meeting, recorded March 1, 2019.
PM, March 1st, 2019. I'll call the Stevens Point Board of Zoning Appeals to order. And could we have a roll call, please?
Weir.
Present.
Bowden is excused. Dockstader.
Here.
Schulist.
Here.
Odogba.
Here.
Markham.
Here.
Oliva.
Here.
We have 6 present. With Bowden's absent, Markham would have a vote as a board member. Mr. Oliva, you would not have a
Right.
vote
Okay.
unless there is an absence when action is taken.
Just a few opening comments. First of all, regarding voting and so forth, Mr. Oliva, during the presentation and testimony, I'll allow you to ask questions.
Okay.
However, once I close testimony and we go into deliberations, then I ask you to just observe. This case is a case of Kent Warzella doing business as Kent Service and Towing. The case, we initially convened back in July, and at that meeting, we postponed a decision to allow the applicant to do 2 things. Number 1, for a clear statement and graphic representation to be prepared by the applicant to show the impact of reduced setbacks as approved by the Common Council via a conditional use permit process on the operation of the property. Additionally, the applicant should provide a site plan showing how the property would be utilized under all setback measures discussed. And secondly, for ample time to be provided to the applicant to pursue potential options for a solution as discussed. We attempted to complete this case in September. The applicant apparently wasn't prepared at that time. December was not prepared. January was not prepared. And ultimately, council contacted the applicant's attorney, and this meeting has been set for today. I would ask that members of the board, with the additional testimony, not as much as possible delve into the record which is already on file. The hearing in July was recorded. All members of the board have been afforded the opportunity to listen to the audio recording of that hearing. Additionally, all board members have been provided minutes and all the documents that were submitted at that hearing. So rather than being duplicative of testimony already presented, I'd ask that members and also the zoning administrator and the applicant, as much as possible, deal today with the new evidence that is apparently being presented by the applicant. With that, Mr. Warzella, you go ahead and present the information that was requested.
Thank you. So I want to start briefly with an opening statement to kind of give you a preview of what we intend to present. Basically, this is a case involving Kent Service Center. It's been operating for decades. The uses of the property that are at issue and that we're requesting the variance for have similarly been in use for decades. And the question is whether or not being in compliance with the parameters of the zoning ordinances and as modified by the conditional use permit would create an unnecessary hardship on a permitted use of the property. And we believe the answer to that question is yes. What we'll be presenting here today is, number one, site plans for review. There are approximately 5 site plans for your review. The first site plan simply depicts the existing zoning requirement, the existing zoning requirements. Which illustrates what compliance with the conditional use permit conditions would look like if the buildings were brought into compliance. And as you'll later see from the video, these are the markings that were placed to illustrate by the video what compliance looks like in action. Actually watching the various vehicles trying to maneuver the property to show that this is in fact creating a hardship that you can actually see in action. In addition to that, we have 2 maps regarding the Clearview areas of 1st and 2nd Street. These are the streets to the east and west of the property. And the Clearview requirement essentially, because this is a property which is bound by 3 streets, which first of all is important for multiple reasons. The first of which is, as the applicant, we have to demonstrate that the burden is due to unique circumstances of the property. There is not another intersection in the city of Stevens Point where that is bound by 3 streets in the manner that Kent's is, especially where you have a non-through street to the west, a dead-end street, 1st Street. So it does create limitations that we'll explain, but basically what these maps illustrate are what the 20 by 20 foot triangle to comply with the Clearview requirements looks like. And if you compare it to the neighboring properties and consider the purposes of the zoning ordinance for that Clearview requirement, which is what the board is supposed to do when an applicant is asking for an area variance to determine whether or not the variance would impose upon or restrict or prevent those purposes. We're showing that effectively the triangle, based on the unique limitations of the property, the effective Clearview area is greater with Kent's property if that full 20 by 20 triangle is imposed than it is with the neighboring properties, based on the manner that the intersections are set up. That is, the curb line extends out to a greater distance on Kent's property than it does on the neighboring properties, meaning that vision is, the vision at the intersection is expanded such that the full 20 by 20 triangle would not be needed to have sufficient clearance there. A proposal on both of those maps is that the requirements be reduced, that an area variance be granted on those Clearview requirements such that the triangle within the right-of-way would be 10 by 10. In addition to those maps, and I'll let Jordan Brost, who's the engineer who prepared these site plans, I'll let him answer any questions of the board pertaining to the technical aspects of these site plans. I'll have him kind of discuss that. And then, in addition to that, we also have the proposed conditions upon variance request. This is ultimately what Kent's is asking for from the board, and it has three components to it. The first is, if you look at the east and the west portion of the property, we're asking that there be a zero setback for parking of vehicles along the east and west side of the property. The reasoning behind that is, number one, again, we're not having a conflict with the purposes of the zoning ordinance in protecting or promoting public health and safety and the concerns set forth in Chapter 23 in that purpose statement of the ordinance. First Street is minimally, if ever used, it can go months to maybe even years without being used, not regularly used by the public. And so asking for the 0-foot setback to accommodate the burdens imposed due to the history and nature of this property is what we're asking for. If you go back in time, and again, I'm not trying to reiterate things that the board should be aware from reviewing the materials, but essentially, when the 10-foot strip of property was condemned by the city, not only is that a 10-foot burden reducing, or that 10-foot condemnation taking away 10 feet of usable space, but then adding into that compliance with the setback, then you're either looking at the 10-foot setback from the conditional use permit, or if that conditional use permit not in effect, 25-foot setback for the carport canopies, which is a vital portion of Kent's business. If you look at the City Planning Commission's findings relative to the conditional use permit, and again, the conditional use permit was something that Kent's pursued under the understanding that it was necessary to pursue this variance. That's not true. I don't believe they would have to pursue the conditional use permit in order to apply for the variance and the relief requested from the board here today. So in any event, what's being asked for, again, are those, the parking reduction to 0 feet, the triangle clear view requirement on the east and west corners of the property. Instead of that 20 by 20 within the right-of-way, we're asking that it be reduced to 10 by 10. And then third, reduction of the setback for the carports, again, be set to 0 lot line, as well as 0 lot line for parking of the vehicles on that, along that border of the property. And again, this is simply a situation where there was no land to give under the way that Kent's was being operated. It was already pressed to the max, and then 10 feet is lost, an additional 10 feet by the setback requirements if those were complied with. Ultimately, you'll see from the video, it's not possible to maneuver a vehicle into the garage under typical conditions on the property. And that is obviously a permitted use. It's zoned for that particular use. And we believe that it's an unnecessary burden because we don't believe that non-enforcement of those various setbacks would have any implication on the purpose of the zoning ordinance, which is what the board is to consider. So I think the best way to go about this, again, I want to first just briefly touch upon some of the findings, because I think that they are of importance. And I understand that the City Planning Commission findings are not by any means mandatory upon this board, but I do believe that they are helpful. While I try to locate that, I think what we'll do is set up the video and demonstrate in action the limitations of the property with respect to use, and I'll have Kent narrate that video for the board so that they can understand what's going on and what's being depicted. Before I show the video, I guess I would ask Rob Postoluk, he's the individual who filmed the video, to simply indicate how the video was created and so on for purposes of the record. Rob, can you explain to the board what the video is, how you took the video, what it depicts, and purposes of the record?
Come up to the podium.
So-
Your name and address for the record, too, please.
Sure. It's Robert Postoluk,
Spell the last name.
Posteluk.
Okay.
Address 9842 Amber Drive, Marshfield, Wisconsin.
Thank you.
So the company that was hired is Trimedia. I'm a part owner of that company, and we used drone. We have licensed pilots to fly drones and look at the aerial shots. So no different than a GIS concept, same thing that we would do with our drone. So on the day that we were contracted to come out, it was a very snowy day, but we decided to go airborne anyway since our visibility was still there. So we went to flight, and we were able to record the property with all the setbacks marked, with the vehicles positioned where the setbacks would be impacted, and we're able to depict that in a visual sense that each one of you could actually see how it would look if everything was moved to what was asked. Yes, ma'am.
Can you describe what you mean by, you said the vehicles were placed where the setbacks would be impacted? So the vehicles in the video are within the required setbacks or no?
Yes, correct. They're what the desire is for the city to have them at, that's how everything is positioned.
Okay,
Yes.
thank you.
Are there any other questions?
No. Could we show the video at this time?
Yes, you may. And the video will be narrated by Mr. Warzel?
Correct.
Okay, not, okay.
Kind of odd that we're all facing away from the screens.
It's great for the audience.
I have an 8-level fusion in my neck. I was rear-ended, so I can't turn around very well, so I'm going to have to stand in front of it. See?
It's,
If you need it paused, Ken, if you need it paused at any point in time, just let Rob know so that we can go.
Why don't you keep it paused right there? Jordan, from Kind of Beginnings, came out and staked all the measurements, true and accurate to the world. We had everything painted out in nice pink, so you could see it really good until the snow came. But these are the side of view triangles at the east and west ends of the property. These are the model ports that are being asked to be moved forward. These barrels indicate that's how far they would come forward. So this space here would continue all the way through after these would be moved forward. These trucks and these trucks are all meeting the setback that they're asking for. So that leaves this space here that's left in the parking lot.
Ken, I have a question, if I may, Board.
Yes, you may.
Can you clarify what the setback of the vehicles are parked at along Maria and then what they're parked at along First Street?
What there's here.
Right, so I guess, what is the distance from the property line?
The vehicle is, the bumper is sitting right on the 10-foot setback.
What is it along First Street?
Along
The-
First
the-
Street,
the
that is
trucks?
5.
Okay, thank you.
That is 5. Yeah, exactly what it's supposed to be.
And the buildings have not been moved at 10 feet?
Correct, yeah. These
So
barrels
the buildings
here,
are on your property line?
What's that?
The buildings are on the property line in this,
as of right now, correct.
but the requirement from the conditional use permit is that they would be
Move
lined
forward
with
10 feet.
the end of the vehicles on Maria Drive.
Correct,
And then the vision triangle is the 20 by 20?
correct,
Okay,
correct.
okay.
And can you show where the 25-foot setback from Second Street is there?
That was
So
in
if I may,
the
the
minutes.
tw- the-
It was presented at
Because
last
it,
time.
because of the conditional use permit, currently the setback would be 10 feet, which is what is marked and what we're going off of based on the video. And again, one of the findings of the City Planning Commission was that the only place where the carport buildings could be placed feasibly to allow access to the repair bays was on that southern border of the property along Maria Drive. So we don't have marked the 25-foot setback. I think you can tell that if those buildings were moved 25 feet, there wouldn't be, it would be a little ridiculous.
This building is
So-
21 feet long. If it got moved 25 feet forward, it'd be right here.
Oh, it wouldn't be,
But I'm,
your 25 feet is not the requirement. The requirement for that building to be moved to the north is 10 feet, correct?
Correct.
So
Yeah.
25 feet is not a player on the south end of those buildings.
Okay.
Can I clarify,
I
Mr.
would
Weir?
appreciate
So, the Common Council granted a conditional use permit to require, or to allow for a reduced setback from 25 feet to 10 feet on Maria Drive.
right.
However, the variance request is not a variance from the conditional use permit, but a variance from the underlying zoning standard, which is 25 feet from all streets.
Can I ask a clarification
Sure.
question? So as it stands today, as the ordinance applies, and if the conditional use was used, is it accurate that the setback required from First Street and Second Street would be 25 feet, but the setback from Maria would be 10 feet?
Correct.
For the structures, that is
For
correct.
the structures.
And when you apply the conditional use permit that was granted.
Right,
Yes.
okay.
Everything here too, I wanted to point out, nothing is staged. Everything that was here was what was on the lot, and I just went to go move it and shift it. Obviously, that varies every day. Some days I have 15, 20 Penske trucks, some days I might have one or two. So, as I said, again, nothing staged, everything was just there, so we just moved it to where it needed to go. This is all live.
Can you stand by the microphone so we get this on audio?
I really can't, 'cause I'd have to go back. Okay, all
But
right.
there's a screen.
I can go this way?
Yeah.
I like the bigger screen, I got bad eyes. Okay, this is, freeze. Oh, it took away the color.
This player darkens through there.
Okay, good job. Here is our side view triangle. You can see when these cars are navigating to the stop sign and where they're stopping, they're beyond that side of view triangle that they don't have to look through to see oncoming traffic. That's in the triangle. This second car isn't still, the driver's still past the side of view of even the buildings. So the buildings aren't blocking any view of anything. And there's plenty of room on the side of view. As you can see, there is a snow advisory at this time for driving conditions. The snow is coming down pretty heavily, and you can see the three cars are able to make it, as well as the cars coming from the east, that everyone's able to navigate the intersection
Mr.
under
Warzella,
these conditions.
let me reiterate what the zoning administrator requested. Please stand in the vicinity of the microphone.
I have a question over here.
My question is, can you show us on this image where the stop sign and the line is? Coming from Maria onto Second there?
Stop sign's right here.
Can we switch to the aerial view and see where the stop sign is? Well, that is aerial,
That is aerial.
yeah, okay.
I'm able to pull up an aerial photo after the video if you wanted to see that further.
Okay.
I think you'll also see, it'll be a more direct
turn on?
overhead, a more direct overhead view coming up in the video, so we can pause it at that point as well.
It's a video, I can't.
That's okay.
I'm thinking, yeah. Okay.
When it goes to video,
It doesn't, yeah.
Okay. All right, go ahead, Ron. See, the vehicles are pulling up. They're able to look both ways and navigate out with the buildings or the side view triangle, not even a factor. This here is a dramatization of a wrecker pulling in with a mid-size vehicle onto the lot. As it was being filmed, there are a Penske truck and the fella's ride pulling in just before I got there. So I told Brandon, who was shooting the drone, to stop. We have to start over. And I thought, well, this is real to the world. This is what happens every day. So now I have to navigate in between the customers that have come to my shop. As I make it through between them, I need to swing out and back this vehicle into one of those 4 bays, depending on which one it's going into. So as I'm trying to make my swing, you can clearly see it is impossible to be able to back that vehicle in with the space that's left. Can you freeze that? Inside the vehicles to the building is all that's left for me. This is the shortest truck that I have. The next one I have, my flatbed, is 10 feet longer. I can't pull in with that vehicle. If I have a vehicle that a ball joint broke and the control arm came off with the wheel, we'll get that loaded on the truck. I can't bring it to the lot and set it down because how do I get it in? It only has 3 wheels. We typically back it in, raise the hoist arm up, swing the arms underneath the car, raise it off the truck and pull the truck out. With this arrangement here, I'm unable to get in with that flatbed. Okay?
Mike?
Yes, please. If you see on the top of the screen, there's a plow truck that we're repairing that's coming out of the garage stall. You can clearly see that what's left for space here is not very much for me to back out. I am an authorized Blizzard and SnowX plow dealer. I'm a commercial contractor, and I do repair of all makes and models of snow plows. When Jordan came to take some measurements in math, we happened to have 7 plow trucks on the property at the time in for repair. So it just makes it really hard to navigate in and out of the building in such a tight radius. Okay, go ahead. That's the end, okay. As I said, I would like to have gotten the flatbed on here and some more footage, but the weather was getting so bad the drone had to come down. So we did take some pictures. If we're allowed to show those, I can show some pictures.
We already have photos of the lot without the snow and
Okay.
file.
I have a picture showing my flatbed trying to unload a car in the distance.
Do you have sufficient copies for all members of the board?
I have just like the video. And they are on the same hard drive as what the video is.
They're in an electronic format.
Yep.
So then we would have the electronic format, we can,
As long as the flash drive is left with the board,
Yep.
Mr. Ellison, we
can have- we can have the
flash drive?
Yes,
Thank you.
that's correct.
so we can have, make a copy of it.
Okay, here's a picture of the flatbed wrecker bringing a broken-down vehicle in, and this is from the west facing east, showing that the truck exceeds the vehicles parked, so I actually had to move vehicles to be able to pull in to unload. Go to the next one. This picture here shows the overlap of the truck versus what would be parked in the lot trying to unload. And you can see that the bed is like inches off the building. We normally don't like to operate that close, so we don't damage vehicles when we're trying to get them loaded and unloaded in and out of the repair shop. Next one. These were just pictures showing the amount of room that is available for someone coming to the stop sign here, from here all the way to here, that if those trucks came back, the extra 10 feet that I'm applying for, I don't feel that it would be a harm, especially that this street isn't even a through street and there's nowhere to go. I own all the property around it on the east, and the school owns on the west. Bruce owns the buildings on the end, so the public there's nothing to go there for.
Mr. Warzoa, could you back up one photo?
Sure.
I have a question.
Mhm.
Cintas. They also are showing two Cintas trucks on these diagrams that
Correct.
were done by the surveyor. Do those vehicles belong to you, or are
No,
they,
that's a fleet.
it's a fleet?
Yeah, Cintas does uniforms, rugs,
Okay.
rags.
Are they normally on your lot?
I take care of the entire fleet for the city of Stevens Point. There's 26 trucks. I normally have 2 to 3 being repaired and rotated out on an average.
Okay, so you just, but they're not there every day?
Yes, they are.
They are there every day?
Yes. Yeah, they have a very strict, Cintas is, I think, number 3 in the US for the amount of fleet vehicles on the road. Their DOT requirements, we're doing inspections on them. Every truck is inspected once a month.
Well, I was just, because of the fact that you showed it on the diagram here, I was just wondering whether they're there all the time.
They're there all the time. Yeah, one or another of the 26 is there.
Okay, thank you.
And we tried to illustrate that if you note, there's a notes section on the site plans. In the notes section of that proposed conditions, it indicates that the map represents the conditions the current owner would be subject to onto the next part. Vehicles shown in the legend represent standard vehicle types used on any given day at the current business location of
I
this
was-
property.
I read that, so
Okay.
I just wanted to clarify. Okay, proceed.
Continue?
How many photos do you have, sir?
11 total.
Just a couple. Continue the next one. This is kind of a picture showing the sidewalk and then what the 10-foot space would be. The brown building, or the carport, the model ports, would be moved forward. So the space from the truck to the snowbank here would continue all the way down here. That's almost the width of a lane of traffic for a street. That is very much needed room for me to be able to navigate my lot. Next one. This is just another view showing how much of the street and what is available there compared to this much on my lot that is an allocated through street that traffic doesn't travel on at all, and I'm 5 times wider than what the city street is that is used and traveled on. Next one. That's just another picture depicting the same scenario. Quite a few doubles. You going the right way? I think it's circling around. Yep. Okay,
Thank you.
that's all we have.
And now, I think I'll have Jordan introduce himself, talk a little bit about the site plans, and in particular, the Clearview triangle site plans to kind of explain what it is we're stating there. Jordan, can you introduce yourself if you want to take to the podium, state your name and address and occupation?
Jordan Brost. My address is 5709 Windy Drive, Suite D, as in dog, Stevens Point, Wisconsin, 544-582, excuse me. Professional land surveyor with Point of Beginning. Mr. Rozzella contacted me to prepare the site plan you're all looking at. I don't know if you wish to prefer to go over each sheet individually and answer any questions you may have.
Well, first, just to establish some background, how long have you been acting in the capacity of a land surveyor?
I've been a professional land surveyor for 7 years. I've been with Point of Beginning for 6.
And the survey maps and site plans that you prepared, are these prepared using the requisite skill and required for a land surveyor under the state of Wisconsin?
Correct.
And the markings that were depicted in the video that we just watched, you assisted in laying those markings?
Correct.
And those were accurate and true representations of the requirements imposed by the various setback requirements at issue here?
That is correct. We used a survey grade total station, so accuracy underneath 1/100th of a foot.
Now, if you could walk us through, first, the site plan entitled Existing Clearview Area of First Street and Maria Drive, and then on the right-hand side, it's the proposed Clearview area. Can you tell us what measurements you took here and what you were comparing for purposes of these depictions?
Each side, obviously, on the left side here, you have existing Clearview area. This kind of imitates or kind of explains what the existing conditions are. We located all the necessary improvements on that street, including asphalt, back of curb, sidewalk, and obviously calculated the right-of-way on all 4 quadrants of that intersection. Based on them calculations and overlaying this 20-foot by 20-foot Clearview area as stated in the zoning code, I delineated the distances from the furthest Clearview point, which is shown on each right-of-way line there, to physical distance to the exact where the back of curb is currently. For instance, northwest quadrant, you're looking at a 31.2 feet distance from the Clearview to that back of curb. Northeast quadrant, you're looking at 41.7 feet in relationship to the other 2 distances on the south side as well. And as you can see, the 41.7 feet is the most distance out of all 4 quadrants. The northeast quadrant, obviously Kent Rozzella's property, the northeast
I'm
quadrant.
going to interrupt you for just a second. I'm going to have Rob put the site plan up, just in case you want to refer to it or point to anything. You have the site plan now being displayed.
First Street and Maria Drive.
There you go.
Yep.
That one, yep. Okay. All right, you can proceed.
On the proposed side, which is the right side of the existing site plan you're looking at, Mr. Waziller is proposing is to match the side of view triangle the same as on the south side of Maria. And obviously by shifting that same distance of that 31.7 feet to the existing back of curb, same as obviously on the north and south side of Maria, matching that same distance, the affected area of that triangle after being moved to that 31.7 would only be subject to a 10-foot by 10-foot clear view area versus a 20 by 20 foot. Are there any questions on page 3?
You want to address the Second Street intersection.
Page 4 of 5 explains existing Clearview area on Second Street and Maria Drive. Kind of the same scenario, existing Clearview area on the left side, showing the 20-foot by 20-foot Clearview triangle on each quadrant, and the related distances between the furthest triangle point to the existing back of curb of each street. These back of curbs and asphalt pavements, sidewalk, all the improvements were located with a survey graded instrument, including the carport and canopy, exterior boundaries of them buildings or enclosures. Obviously, as you can see on that existing Clearview area, Mr. Wazirla's property, which is the northwest quadrant of that intersection, extends to the furthest distance in relationship to the other 3 quadrants. The proposed area, obviously, is again matching that same distance on the south side of Maria to that 23.9 feet to the existing back of curb, as well as on, same as on the south side, which would result in a subject to a 10 by 10 Clearview area, not a 20 by 20. This obviously shows that in doing so, this 10-foot by 10-foot area, that existing canopy and carport would actually be clear of that right-of-way Clearview by 6.2 feet. Is there any questions on page 4?
Oh, yeah, I got the question. So by taking that back in towards Second Street, that was just going right into the right-of-way?
At the extension of that right-of-way line, that northern line, right-of-way line of Maria extended to the east.
Right.
We're basically just shifting that triangle along that northerly right-of-way line.
That's what I thought.
On page 505 of the site plan packet, this kind of represents, the variance request as a whole, where the current carport and canopies are, existing garage. Actually, that garage is actually the same as a canopy and carport, it's just with metal sides. So it's not considered an actual structure. This shows what the proposed vision triangles, subject to that 10 by 10, accommodating that 0 setback along Maria Drive, along that right-of-way line. With that being said, you can still see that we're on each right-of-way corner on both Maria Drive right-of-way. The actual right-of-way is about 1.5 feet north of that sidewalk. So which means that obviously the southern limits of each of them buildings, along with them vehicle description types you see, will be parked on that 0 lot line, more or less 2 feet north of that sidewalk. And as you can see here, with them possible vehicles being parked there, obviously, like I said, these vehicles change every day. The distances in between, more or less the front end of those vehicles, to the service shop there are still quite tight in relationship to the existing vehicles that Kent currently uses. If you look on page 105 there. Page 105 shows all the vehicles that Kent uses on the property, and they also show the dimensions of them vehicles. And when related to these these distances on page 5, it's still quite a bit of a task to maneuver them vehicles, even if the variance was granted.
In your opinion, would it be possible to maneuver the vehicles if, in the absence of the variance, and if those buildings were set back further than where they are now?
It'd be near impossible, in my opinion.
Just a point of clarification relative to the clear view triangles. You're measuring, or does Kent's benefit if we shift that triangle as you have to make it the 10 by 10 versus the 20 by 20? Does Kent's benefit relative to the rights enjoyed by other property owners in terms of having a greater distance from that right-of-way line to the back of curb?
Are you looking on the existing side, or are you looking at the proposed side?
At the proposed side. So, but my understanding is you measured the distance from back of curb to the right-of-way, and we're looking to have, the, when that triangle shifted, the remaining distance from the end of that triangle to the back of curb is the same as the adjacent properties.
To the south. And there's still a greater distance in relationship to the other two quadrants. So what we're doing there is we're matching that greatest distance, actually that common owner to the southeast quadrant. Even with a subject area 10 by 10 clear view area, we still have a clear view distance greater than the northwest and southwest quadrant of that street.
So, in other words, your visibility at that intersection, even with the variance, would be greater than the adjacent intersection.
Correct.
Are there any questions pertaining to the site plans?
Do you have any, Kyle or Logan?
I do not have any.
Well, let me start.
I have one. On page 1,
Yep.
the dotted line, is that a 5-foot setback? Is that, it's 10 feet along Maria, it shows, but what is it on First and Second?
If you look at that label there on First Street,
Yeah.
you'll see that 5-foot parking setback.
That's a 5-foot parking setback?
Correct, yep.
Okay.
As well as on the east side along Second Street too.
Okay.
Other members of the board?
Could I ask a question on the current zoning clarification for any type of business, whether it's a dealership or whatnot, that parks vehicles of some sort? Is there a 5-foot setback requirement?
So it varies based on zoning district. This
Okay.
property is zoned B4 commercial.
Okay.
And the setback in the B4 commercial district for parking is 5 feet.
Okay, thank you.
Mr. Roast, these site plans were drafted and drawn by you on the 26th of February, is that correct?
Correct, yep.
When were you contacted by Mr. Wirzella?
We were contacted by Mr. Brazilla around late July. Field work started actually mid-August, but didn't get completed until actually middle of September due to the scheduling of my current crew chief. So the final field work, or the preliminary initial field work, was completed around mid-September, end of September.
Okay, and then from the notes and,
Pardon?
so from the calculations that had been done, that's when you actually drew these up?
Actually not, no. Actually, the field works was completed in the middle of September. I, however, obviously with the workload in the fall with construction season before winter, I was trying to take all more or less the heat off my other crew chiefs, helping them out in the field. I actually wasn't able to get to this till about middle of January.
That's all I have. Any other members? All right, thank you, sir.
Thank you.
Now, previously, I was referring to some of the findings of the commission relative to the property. I have those actually quoted in the materials that I provided prior to the first hearing. One, and again, I'll
What page is that, sir?
so they're going to be on pages 36 and 37. So I want to preface this with purpose and intent of the zoning code, and this is pursuant to the city's zoning provisions under 23.01 sub 4. The purpose of the ordinance is to promote the health, safety, morals, prosperity, aesthetics, and general welfare of this community. And again, it's the intent to regulate and restrict use of all structures, lands and waters, regulate and restrict lot coverage, et cetera, et cetera. Promote the safety and efficiency of streets and highways, and so on. And these are the types of public safety concerns that they're looking at. There are no issues here relative to public facilities or utilities being impacted. Additionally, it talks about conservation of natural resources or preserving and promoting the beauty of the community. So obviously an element there that the City Plan Commission looked at, and I think this board it would be required to look at, is visibility at those intersections. That is a valid concern that the board has to take into consideration. I think Mr. Brost explained how it would still be addressed, and in fact, you would still have better vision at that intersection even with the variance. But in addition to that, the City Plan Commission, if you look at page 36, talks about the location of those carport structures, indicated that they had been placed there similarly prior to the road expansion project. They're now visible from the right-of-way but do not appear to impede traffic or visibility. The one concern that was noted by the City Plan Commission was that having it in close proximity to the property line may be detrimental to utilizing the road and sidewalk. Again, it's our position relative to that concern is not founded. We're not aware of any instances where there were complaints relative to those utilizing the sidewalk. In fact, it actually creates a buffer between the commercial uses and vehicular traffic on the property and users of the sidewalk. So those buildings actually kind of create a safety barrier there, keeping users of the sidewalk away from moving vehicles. If you look then on page 37, this was another important discussion. Number one, indicating that the property is uniquely shaped, and the findings concerning of the City Planning Commission here were that, again, the only feasible area for the accessory structures exists on the south side of the property, and which is unfortunately bounded by 3 streets and significantly reduces the usable area. So again, the question before the board, and it may be argued that Kent's created this hardship, and I don't believe that is a valid argument that the board should consider, because Kent's didn't ask for its property to be condemned. It's a process that, even if it wished, it was not going to be able to stop. Again, the fact that it entered into a settlement, again, the purposes of which are to stem further costs and expense to Kent's as a business, the interference associated with that condemnation proceeding, had he chose to forego doing that, Again, a court would have simply determined the value of that property, not taking into consideration the invaluable nature in terms of his day-to-day use of the property. So again, the impact in terms of ongoing day-to-day operations and revenue for Kent's is dramatic. The actual value of the 10-foot parcel of property obviously pales in comparison. So we're looking here at the effects of that, and that reduced area, again, is what is imposing this burden. So looking at the various, or looking at, again, referring back to the purposes, we don't believe that any of the purposes of the zoning ordinances are being conflicted with or disrupted by what's being requested by Kent's with respect to the various variances at hand. Vision is not an issue, and clearly you've heard and you've seen that it would be impossible for the already burdened parcel to continue the uses that it has if compliance is made with the various setback requirements. Again, the standard of review, just to clarify, in the initial submission, and I believe there was some debate, and there may continue to be some debate about the legal standard that applies in this situation. In the staff report prepared by the city, they quote some language from the zoning handbook that basically equates the area variance standard to the no reasonable use standard for a use variance. Again, Kent's isn't asking for a different type of use for the property. He's asking that he be given relief from the area setbacks, and that simply to continue the permitted uses of the property, which are longstanding. The Ziervogel decision, as well as subsequent cases such as Waushara County, indicate that the no reasonable use standard for area variances has been abandoned, and to suggest that the area variance standard or hardship cannot be shown if there is any reasonable use of the property is not accurate depiction of the state of the law. Both the Supreme Court recognized in those decisions that zoning boards have to have discretion and flexibility to address situations such as this. Again, board has to take into consideration the purposes of the ordinances, and I think that the Waushara County case is a good illustration of the interests at hand, and how this case is in fact more compelling than that one. In that particular case, an area variance was granted for a homeowner who built an expansion, a garage expansion on a lakefront property, which was within the setback from the lake that was set by the zoning ordinance. Obviously, the zoning ordinance places that setback requirement from the lake to prevent flooding concerns, and there are valid reasons for having that ordinance in place. However, the building was constructed prior to the zoning ordinance, and already there were variances for the structure to be located where it was, and ultimately, when the zoning board denied the applicant's, the zoning board granted the applicant's request to have a garage expanded onto this property because the owners intended to use it as a permanent residence when they retired instead of just a vacation home. And the reasoning behind it was they weren't getting any closer to the lake than what was already permitted. The appeal was sought by the zoning board. The circuit court stated that it was not, that the circuit court reversed it actually and said that the zoning board didn't get it correct. That was subsequently appealed, and there is where we have the recognition that zoning boards, that's within their authority, and they have to have flexibility in those types of situations. Because we weren't getting any closer to the lake, and because without having that, that would interfere with their ability to use that property as a permanent residence, that we weren't impacting any of those purposes of the ordinance, and ultimately, the homeowners were allowed that variance. Here, we're not talking about, you know, Kent's wanting this for purposes of convenience, or, you know, he's not converting the vacation home to a permanent residence. This is his day-to-day operations of his business. And without this variance, without the requests that we have set forth, he's not going to be able to continue significant portions of his business. He's not going to be able to operate the flatbed trucks and tow trucks to get vehicles into the repair bays. And so I think that the implications of this are greater, and more justification is there than in the Waushara County case. So very clearly, it is within the board's power and authority to grant this variance. And again, we're asking that it do so to alleviate the burdens that Mr. Warzel is facing with the property.
That is, sir?
Right. And again, these are the result of the unique nature of the property and circumstances outside of Kent's control, such as the condemnation of the property. Again, I think that what's being requested is a balance between the city's objectives of expanding the roadway, which it did successfully. Now we have to look at, okay, are these additional requirements in compliance with them necessary to carry out the purposes of the zoning ordinance, or if the variance is granted, would those concerns still be addressed? I believe that they are addressed. There are no safety or health issues created by the area variances requested. And again, for those reasons, we ask the board to grant the area variances.
Just for clarification, sir, you mentioned several times condemnation. This property was not condemned, was it? It was a potential that the city might initiate action in court to take it. However, it was actually sold to the city, correct? I just want to make sure we were, you know.
Yeah, right, and I think I stated that, basically, essentially, what happened is the city provides a notice that it intends to exercise powers of eminent domain or condemnation. And Kent's, as the property owner, has the right to respond to that, and it can choose to either, you know, dispute that and dispute what the value of the property is, and that could continue on indefinitely until it's adjudicated by a court of law. Ultimately, it wasn't adjudicated by a court of law because Kent's did come to a settlement on it. But I think we have to look at the inevitability of that being adjudicated and that property being taken. There was nothing to, the city had the right to exercise eminent domain, certainly. So I don't think that it's pertinent whether or not there was a judicial adjudication of that particular parcel of property.
Well, I just wanted to clarify that there was not a condemnation per se. The city intended probably to exercise eminent domain, but that was not done. Is that correct?
I think what you're bringing up is sort of the difference between the common parlance meaning of condemn or condemnation versus the more term of art use of that word. You know, most people, they hear the word condemn and they picture a dilapidated building that's being tagged and an order sought to tear it down. Whereas in the use of Chapter 32 to acquire land for right-of-way or whatever, the word condemnation is used there, even though it doesn't necessarily refer to a dilapidated building that's being torn down because it constitutes a nuisance.
I just wanted to clarify that point. Did, Mr. Kearns, do you have any questions of the applicant regarding the testimony that's been presented?
I don't believe I do.
No? Okay. And if you would go ahead and proceed with your testimony?
So the majority of my testimony has already been provided. I have no additional testimony. Now, Logan may want to rebuttal with regards to what the applicants have provided, but my testimony has been provided in the staff report previously. I will be happy to certainly answer questions in regards to the new information provided. Keep in mind that that information was provided to us earlier this week, so we have not had an adequate amount of time to thoroughly review the 5 pages, and this is the first time we're also seeing the video.
Yes, ma'am.
Ask a question. My question is how Clearview area is measured according to city ordinance? Is it consistently measured from the lot lines?
Yeah, so the ordinance specifies the right-of-way line. So in most cases, the right-of-way line is shared essentially with the property line, or they're one and the same in terms of when the property borders a right-of-way. So they are measured essentially at the property line and not at the asphalt or at the curb of the actual street. I do also want to state that there are other instances in the city where the road has not been constructed in the center line of the right-of-way. So, for example, if the right-of-way is 60 feet wide, in most cases, the road is constructed at the 30-foot center line, thus the road is right in the middle of the right-of-way. But there are several cases in the city where the road is offset one or the other way of the right-of-way, which again would essentially replicate the case that the applicant is making, having different lengths from edge of pavement or curb for different properties in proximity of the right-of-way.
Beverage, did you have anything? Well, before you begin, during negotiations with Mr. Warzella, were setback requirements discussed during those negotiations?
Yes.
Yes.
And specifically, I know the settlement was included in your packet.
Yes.
What page is that?
Agreement is.
It is pages 15, 16, and 17.
Thank you.
So if you look at paragraph 4, that would be on the second page of the settlement agreement. It says the city will give the owner at least 2 months advance written notice of the owner's deadline, which deadline shall be after surface ice is melted and the frost has come out of the ground, to make improvements or to move improvements and/or personal property in that portion of the owner's land which is taken by the city, or from needed setbacks from the southerly border of the property. Obviously, that notice was provided in a timely manner. Certainly, I've got a lot of comments here I want to make. If you
I
feel
do
that's the
have an
appropriate
additional
time right now.
question, or is that later?
Well,
The applicant.
Why don't we're off the applicant for the time being. Mr. Beveridge, you go ahead and proceed.
We did hear some comments from Attorney Ellison suggesting that the zoning administrator's report had somehow identified the incorrect standard with regards to an area variance. However, if you look at page 25 of your packet, where it says standard of review, the second paragraph below that, it states, for an area variance, unnecessary hardship exists when compliance would unreasonably prevent the owner from using the property for a permitted purpose, or would render conformity with such restrictions unnecessarily burdensome. So if you want to read the part in the parentheses there as somehow stating the incorrect standard, you know, where it says, leaving the property owner without any use that is permitted for the property, okay, perhaps I can understand that. But I'm going to delve into the standards that I think Attorney Ellison and I could certainly agree on are applicable here, and I'm going to explain why I feel that this request does not meet those standards. So first off, if you look at the statute, which I know you've been provided, it states that this board has the authority. Now granted, you have attorneys here to advise you as the board. I am representing the zoning administrator. I'm making a case on behalf of the denial of this. I'm not providing legal advice to the board, just to make that perfectly clear. So it states under Part 7B of the statute for that establishes this board that you have the power to authorize upon appeal in specific cases such variance from the terms of the ordinance as will not be contrary to the public interest, where owing to special conditions, a literal enforcement of the provisions of the ordinance will result in practical difficulty or unnecessary hardship, so that the spirit of the ordinance shall be observed, public safety and welfare secured, and substantial justice done. Later on in Part D, it states, property owner bears the burden of proving unnecessary hardship for an area variance by demonstrating that strict compliance with the zoning ordinance would unreasonably prevent the owner from using the property owner's property for a permitted purpose or would render conformity with the zoning ordinance unnecessarily burdensome. And at the very end of that paragraph, it says, in all circumstances, a property owner bears the burden of proving that the unnecessary hardship is based on conditions unique to the property rather than considerations personal to the property owner, and that the unnecessary hardship was not created by the property owner. So, first of all, there has to be a hardship. If there's no hardship, there is no grounds for a variance. And the way that the court described hardship in the Ziervogel case, which Attorney Ellison referenced, is saying that if there can be a hardship if enforcement of the zoning ordinance would unreasonably prevent the owner from using the property for a permitted purpose, or would render conformity with such restrictions unnecessarily burdensome. So a permitted purpose. This is a B4 commercial district. Looking at the zoning code, there's a list of permitted uses. Repair shops, obviously the applicant has a repair shop there. Also greenhouses, nurseries, gas stations, mobile home sales, drive-in restaurants, et cetera, et cetera, et cetera. So enforcement of the zoning does not prevent him from operating a repair shop. We haven't heard any sort of testimonies to suggest that it does. It doesn't prevent him from operating in a truck leasing operation. It doesn't prevent him from selling carports. What we're hearing is testimony that it prevents him from operating a repair shop and having a truck leasing operation and having an operation that sells carports. Now, if I looked at this list of permitted purposes here and I said, well, I've got a piece of property in B4 commercial district and it doesn't have enough room for me to have a repair shop and a gas station and a drive-in restaurant and a pet shop and an animal hospital. Well, yeah, of course not. The question is, does it unreasonably prevent you from using it for a permitted purpose? Not does it prevent you from having some arbitrarily large number of permitted purposes all in the same size limited place. So I think to say that there's a hardship here, it is to a great extent self-created. You could just, otherwise I can just continue to add new uses to my property until I run up against the limits of how much space I have and say, I have a hardship now, I'm entitled to a variance. Obviously, that's a ridiculous interpretation of it. Now, ignoring the hardship aspect, the hardship has to be due to a unique aspect of the property. And we've heard that the unique aspect is alleged to be that it's bounded on 3 sides by right-of-way. Well, it's not the only property in town that's bounded on three sides by right-of-way. In fact, that is a common enough consideration that the zoning code itself contemplates exactly that scenario happening. And it allows for, via a conditional use permit, reduced setbacks on one side under those circumstances. Not only that, but Mr. Warzella applied for that conditional use permit and was granted one. That's why he has a reduced 10-foot setback as opposed to the 25. So I'd ask you, if this is truly a unique property condition, how is it that it was contemplated in the zoning code? I mean, it's like saying that my square property that's too small to have a duplex built on it is unique for some reason. It's like, no, we have a section of the code specifically for your type of property because it's a common enough configuration that we thought to include something that describes it. So there's a safety valve to allow some relief that's specifically written in here. So essentially saying, well, that's not quite good enough. We heard some suggestions that the unique aspect of this was due to First Street being a dead end there and not really having a lot of traffic on it. Well, if that's the unique aspect of it, I think that cuts in the wrong direction in the sense that it's a right-of-way that has a very, very low amount of traffic on it. Therefore, it means that he can maneuver trucks on and off of it without having to obstruct traffic, without creating any sort of safety hazard that'd be common with a through street. I think if anything, it means that there's less of a hardship in virtue of the First Street being the way it is right there, as compared to a property that has through streets on three sides. So I think that that the unique aspect of the property is not present at all here. Looking at the public interest element that's identified in the statute. The Ziervogel case, we heard referenced, it's sort of the seminal case here. We also heard reference to the Waushara County case. Both of those are cases where the variance sought related to shoreland zoning. In the Ziervogel case, the request was to be able to put a vertical addition onto an existing lake house that the existing structure was not in compliance with shoreline zoning setbacks. In a case like that, you'd say, well, what is the public's interest in strict enforcement? Well, aesthetics, perhaps, the idea that somebody could have a rickety old shack with a toehold in the setback area and maintain, half the kitchen and then add a mansion onto it, that sort of thing. Preserve the natural character of the shoreland riparian area, you name it. That's the public interest that's at stake in those types of cases. Those are not safety concerns. Here, we're talking about a request to modify clear view requirements for intersections, to request setbacks off of a sidewalk that's a block away from an elementary school. And I think one of Attorney Ellison's arguments, it kind of tries to pull in two different directions. We heard him suggest that having the buildings situated immediately next to the sidewalk creates a buffer between that sidewalk and the vehicular traffic of these large trucks on the property. Okay, if we grant that as being a good argument, then that's exactly the argument against why there should be a reduced setback for these incredibly big trucks right next to a sidewalk. And you were talking about having somebody back this thing in to within 24 inches of a place where young children walk every school day. So the public interest in the Ziervogel case and the Waushara County case, it was held to be satisfied because the public wasn't being drastically harmed or anything like that. Nobody's safety was being imperiled by having a garage be a little bit closer to the water line. Here you've got a request from two different standards that are both directly related to safety and also aesthetics, but certainly with regards to landscape buffer and everything, that's an aesthetic concern, but it's also definitely a safety concern. So I'd argue that the public interest requirement is not satisfied either. With regards to the substantial justice element, typically it's kind of hard to put your finger on exactly what a substantial justice element would be in the context of a zoning variance. However, I think there really is one here, and it's clear. I referenced earlier the settlement with Mr. Warzella. He was paid a substantial amount of money for the city to acquire that right of way. And as I mentioned, it was contemplated expressly in that agreement when it was negotiated that setbacks were going to exist along that southern border where previously it had constituted a side yard. And we all went into that, eyes wide open, and signed an agreement. And the city cut a check or 2 different checks totaling over $41,000. Obviously, part of that was to compensate for attorney's fees to the attorney who represented Kent, but a substantial portion of it, $34,900, was for the real estate acquisition. By law, a portion of that is to compensate for what's called diminution of value of the remnant parcel. This was a partial taking. We did not take the entire property, we took a strip of it along the southern edge. That leaves a remnant parcel, the portion that Kent owns right now, that's a little bit smaller than it used to be. And there's an effect on the value of that. So you have the value of what's actually acquired, and then you have the shrunken value of what the remnant parcel's worth. And the statutes say that you have to compensate for that. So when he signed the settlement agreement, he was acknowledging that he'd been fairly compensated. So I think to then come back and say, well, this is unfair, I would say, then why did you sign this? And, I mean, obviously, we had some comments with regards to there's the cost of litigation and all that, and certainly, but it's not like this was just taken from him with no compensation. There was quite a bit of money paid. Everybody understood what was going on with regards to setbacks. So I think in terms of the substantial justice here, that element really is something worth thinking about. And I would argue that it would be a violation of the justice due to the public taxpayers for them to cut a check with the city staff's understanding, the council's understanding when they approved the agreement, that the setbacks would be complied with, and then to have a request now that he not have to comply with them. So I did hear one comment here, getting back to sort of the self-imposed hardship aspect. I heard a comment that said that this was already pressed to the max. And I would agree that this was a property that even before any of the condemnation or anything occurred was pressed to the max. If you look at the existing conditions site plan, the very first page of the big sheets you got, you can see those trucks on the southwest corner of the property extending over the property line. So essentially what that means is that these trucks had been parked in the city's right-of-way. Now, in theory, the city could have gone and issued an order and said, you're not allowed to park those there. You're literally parking it in the road, essentially. But apparently it was not a huge concern, or for whatever reason, accidents of history, things don't get enforced. But ultimately, you can see that this was, even as the use was in the past, it didn't fit onto the property. So, if the city had come by and ordered him to remove those from the right-of-way at the time, would that have been a situation where you would have had to say, well, geez, maybe I can't fit quite as much onto my property as I'm currently trying to do? I don't know. That's hypothetical. But again, I think the decisions that Kent made to add additional lines of business to the service garage business is something that he chose to do. And if he ran out of space as a result, that is a self-imposed hardship. And one other thing with regards to the presentation we saw, if you recall the video, I think the chairman had asked if it could be backed up one slide. When we saw the photo of the flatbed truck unloading the car, I heard a comment from Kent. He said, I had to actually move vehicles to be able to do that. And I couldn't help but think, yeah, that's a thing that you have to do sometimes when you're operating a place with large pieces of equipment. And it doesn't matter whether you have all the space in the world or something that's more confined. You're going to have to move things around to make day-to-day operations work. That's not an undue burden or hardship. That's just a normal aspect of operating that type of facility, that you got to shuffle things around a bit. I mean, go and look at any number of other auto repair shops in town. Some of them are incredibly small lots. A lot of them are on corner lots too. I mean, we all know the ones, you know, whether it's Check's Muffler or the one kitty corner from here. And they have to shuffle things around. It happens all the time. But these distances here, the suggestion that it makes it unduly burdensome to comply with the setbacks, saying I had to move some vehicles around, that doesn't sound like an undue burden to me. You know, if it was, it literally doesn't fit, things just don't fit through here, there's a big difference between that and, well, it's kind of tight, but we can make it work. And I think what I'm seeing here at least is, well, it's maybe a little bit tight, but you can make it work. In fact, if you look at the existing zoning requirements site plan, which is the second page, and you look at those same trucks on the southwest corner, you see a 29-foot separation between the garage and that northernmost truck. And it struck me as I went to the proposed conditions upon variance sheet a few pages later, that I looked in that spot and saw still a 29-foot gap. I thought, wait, so there's a reduced setback, but you still have the same clearance there. And then I realized, oh, well, there's a fifth truck shown instead of four. Which strikes me not as meeting the current zoning is this undue burden, but I'd just like to be able to fit some more trucks in there. Well, the standard that has to be found is that it's unreasonably preventing the use for a permitted purpose. Saying I can only fit 4 trucks there instead of 5 hardly strikes me as an unreasonable prevention of ability to use use it for a permitted purpose. It's a fractional decrease in how much stuff you can fit there. You can still rent trucks, can still move them in and out, maybe just not quite as many stationed on the lot at one time. Hence the check that was cut for the compensation when the land was acquired. Nobody's arguing that it's a little bit smaller. So with that, that's everything I have. Certainly I can answer any questions if you have them.
Mr. Ellis?
Yeah, we, a few,
Can we just allow for questions first?
sure.
Oh, no, I'll go to them first.
Oh, okay.
And then back to the board.
Okay.
There are a few areas that I would like to address with rebuttal. And I'll begin relative to the concept that, you know, Kent's Service Center is simply looking to expand an arbitrary number of uses of the property. Well, I don't think we're not talking about, you know, a restaurant and a pet shop and extraneous uses that aren't integrated and, you know, that makes sense. Kent's Service Center services commercial vehicles, it services the Cintas trucks. Those are gonna be there whether or not this variance is granted. And so basically, if the variance is not granted, you are imposing an unreasonable burden because it's not going to be, you're not going to be able to have the service of those vehicles and to maneuver the property in order to accomplish it. Again, there could be more than 5 vehicles parked on the property at one point in time. This is typical. It could be 2 on some days. And I understand that vehicles can be maneuvered, but it's whether or not it's an unreasonable burden. And if you are, every single time a vehicle comes into the lot, you're maneuvering several vehicles over the course of a day, you know it's going to cause an incredible disruption, and that this isn't, you know, a simple matter of convenience for Kent's. This is a matter of we would have to abandon permitted uses of the property using those vehicles, and obviously there would be a detriment to Kent's operating the way that it has. And again, this isn't, Kent's didn't just, you know, decide, you know, how many more uses can we get in here? And they're not asking for the board to approve this variance so that it can get another use in. It just wants to continue business as usual that it has been conducting for decades prior to this becoming an issue. Next, relative to the compensation received from the sale of the property. Again, while you can argue that that Kent's received a handsome sum of money, as was the terms used by Attorney Beveridge. Again, I think that the revenue that is generated on an annual basis is exponentially greater than the one-time payment that Kent's received for the parcel that was lost. In addition to that, the burden and detriment that's imposed by the loss of that land is exponentially greater than the value that was received by that sale of that parcel of land. Kent's could have, like I said from the very beginning, Kent's could have litigated this till the end of time, and he could have spent tens and tens of thousands of more dollars fighting the condemnation of his property. And ultimately, a judge would have said, this is the fair market value of your property, here it is. Now you deal with what you've got. So I don't think Kent's created the situation of having his property sold, even if it can be termed that way. And at the prior hearing, Lisa Warzala testified about the revenues and the use of the property for the commercial trucks, truck rental, et cetera, and what's derived from that. I know there's some new members of the board, but this isn't an inconsequential impact on the business. It's not just a practical thing. We're talking about a substantial burden on the business. We're talking about potentially lost jobs and being able to support employees here, and even the ultimate possibility that the business would not be able to continue in the city of Stevens Point in the absence of the variance. And I think, Kent can tell you that there was never a hardship in conducting any of the various uses of his property prior to being in the position that he is today, subsequent to the expansion of Maria Drive. Do you have any issues doing your business prior to that time?
No, and that's kind of where I'd like to jump in here if I could. My automotive repair, 24-hour towing shop was established in 1989. I've been here for 30 years. Up until this taking, I have had 0 complaints. I have had 0 trouble. I was able to function my business exactly the way I wanted to. When I was looking for locations, I had narrowed it down to this one, which was a good number 2 location streetwise for traffic, versus a smaller shop with a smaller lot on Post Road in Plover,
Sir,
which was a number 1.
excuse me. This is testimony that you presented, or very similar to testimony you presented back in July, correct?
I'm rebutting what was said here.
I didn't hear the part of the history. I don't recall that. I mean,
I don't think it was
the
in
history
notes.
part is new
Okay,
in the years.
proceed.
So up until this time of this taking, I've been able to function my business. I started out with two techs and 4 bays. I'm up to 10 bays. I bought the lots behind me. I did all my expansions. I did everything. I was in no trouble at all, very happy to function until this came about. And the absurdities that Mr. Beveridge is throwing out here, that I had plenty of time. At the time of this condemnation, I am recovering from a car accident where I was rear-ended, and I have an 8-level fusion in my neck. I was paralyzed from the waist down. My wife was in a car accident who had 2 broken shoulders, a ruptured appendix, and had emergency surgery that saved her life for internal injuries. In between our accidents, my son was hospitalized for being hit on his motorcycle with a 3-inch blood clot on his brain. We sat with him for 3 weeks watching him fight for his life when I'm being condemned? Did I put all the time into it?
Excuse me, Mr. Chair. Those things are all important for us to understand, but we appear to be relitigating a condemnation matter, which is really not what we're here for.
I was just about to get into that.
So as far as the values,
You stated, sir, that you were rebutting Mr.
Yes.
Beveridge's comments.
of the.
Please stay on that.
Okay, he's saying that I signed a contract, that I knew everything that was going on, is what he said.
That's correct.
That if I had agreements, that I should have argued them then. I wasn't in the physical health to fight this fight. I am not a legal attorney, and I feel for anyone that has to go through this, to have to know the law and what can and can't happen. I fix cars for a living. I'm not interested in fighting with this. I bought my property because it had expansion room, and I was able to do everything I wanted to do up until this time.
Mr. Chair,
That-
may I
sure.
issue some legal advice for a moment?
Yes.
Okay, this is not the proper forum for us to be rehashing the condemnation. This is not the appropriate venue for the dispute that seems to be being discussed currently. I advise you that we should move on.
I totally agree. So let's move on. Anything, now, question of,
What, you want him to finish?
You want, I mean,
well, was there anything else that?
Yeah, if I may. So, in addition, we talked about, or it was talked about, substantial justice and the notion that, the concept that the carports creating a buffer may cut both ways. Well, again, the alternative, if you look at the maps, I guess any of them will do, but let's look at the proposed conditions variance request. Obviously, the reason we're asking for the buildings to be where they are is it creates the greatest amount of clearance for vehicles to maneuver on that side of the buildings. Kent's, if the variance is not granted, would be within its rights and legal rights to move those carports back 25 feet, be in compliance with the setback requirements originally under the zoning ordinance, and then we would have vehicles maneuvering closer to the sidewalk with Maria Drive. So I don't know why we would want to divert traffic and have them operating consistently closer to Maria Drive than having the buildings there and traffic going around it. Not to mention that the interference in terms of customers accessing the property and the reduced maneuverability of the property that would be caused by that. Again, the City Planning Commission said this is the only place the buildings can go. So it is a unique situation. And again, I'm not aware of a single similar property, and certainly we haven't compared another comparable property to show otherwise. There was discussion in the materials provided to the board originally about a potentially similar property, Check's Muffler and Gullickson's, and again, through the photographs there, we can see that, you know, there's the setback requirements in terms of parking and so on are not being imposed strictly upon these properties, nor the landscape buffer that's being asked for as part of the conditional use, which would require an additional 10-foot landscape buffer between the start of the accessory structures and the right-of-way. So, again, I don't think there are any comparable properties, and it is not a self-imposed hardship. The fact that Kent's has makes, fully utilizes its property should not be held against it, particularly where these uses are longstanding. Again, he's not asking the board to expand what he's doing. These are longstanding uses, and again, I don't see the harm created by simply continuing business as usual, considering that we have no evidence to indicate that these uses have caused any detriment to the public. We can, speculate that it may create a safety situation. There's no evidence of that. Nor would it make any sense. Again, I think if anything, it creates a buffer, and the testimony of the individuals familiar with Kent's at the prior hearing, he keeps the lot tidy. He is, a good businessman in terms of making it presentable. It is as it can be for a repair center, and it is a permitted use.
Obviously, if we went around the town, there are a number of violations for a number of parking setback and all the things we're talking about in other properties, but we're not talking about other properties, we're talking about mine. To make a long story short, until all this happened, I was fine, everything was doing great. Was I compensated? Yes. I have north of $200,000 in expenses to return the things that I lost in this condemnation. If you're asking me to inconveniently just go move a vehicle because that's part of, I never had to move it before. And if I have to pull a tech off of a car that's being worked on for $92 an hour plus parts to go move a vehicle, my costs are gonna double. How do I function? Profit is the number one thing that I have to stay alive. And if I double my costs, that is a hardship. I didn't have any of these problems until this. Do I believe in the street? Yes. My carports that were discussed, they are not accessory buildings. They are model ports. There is a difference. In all our negotiations, it was always discussed that these model ports could be put back on that zero lot line. If you went before this, those ports were literally 5 feet off the street. They were closer than they are now. So I've made a number of modifications to make this work, and I'm asking you, the board. We can sit here and argue to the end, and Andrew and I would do a very good job of that. The bottom line is, you came in and you took 10 feet of my property plus another 25 feet of right-of-way. That's 35 feet. That's 1/3 of my lot. In return, I'm just asking, could I have a zero lot line? I'm still 17 feet off the street, farther than any other intersection in my area with this variance. The right-of-way, or the side-of-view triangles, because of the lay of the property and how the lines fall out, even if we move this triangle forward, I still match the greatest distance of that side-of-view triangle to the curb. I'm not asking to be any closer or have a special, I'm the farthest still away. You got your street, everything's wide. I still need to function. There has to be a little give and take here to get what you needed and yet keep me alive. And if I have to operate under these conditions, I don't think that I will sustain my business here. I can't function that way. I can't pull $30 an hour employees out to go move a car. It just doesn't work. And I can't hire other employees to stand here, well, I might have to move a car today. It's not going to affect safety, it won't affect the city, it won't affect anything. It's something that's already been there for 30 years. Those ports have been up there for 25 of the 30 and hasn't been a problem. Mickey's building was between the ports onto the street, and that street was really narrow, was never a problem. Mickey's building was 5 feet off the street, and it was never a problem. I'm over 31 if you help me get there. I'm 41 now.
And one other thing that I failed to address in the initial discussion that the board may be questioning, because it was asked that he have time to explore these other options. And since I didn't mention it before, in fairness, if Attorney Beveridge wants to comment, I have no problems with that. We looked at potentially to alleviate the burden on this property in terms of the area restrictions. Maybe we can do something over here on First Street. The road is 4 rods wide. It's a dead-end street, and there was discussions of possibly looking to have the road abandoned or a portion of the road abandoned. Kent's tried to pursue that, and the city's not interested. Additionally, he's tried to look into purchasing all the properties adjacent to the dead-end street in addition to the continuance of that dead-end street, meaning the right-of-way if it were ever made into a through street. And, you know, he's, at that point in time, asking the city, okay, if I acquired all these properties, would you then put this through street through, or would you abandon it if I'm the owner on both sides of this street? And still the answer remains no. Mr. Brost could tell you that especially the western portion of First Street as it extends to the past the dead end portion, as he was doing his surveying, this is all marshland. So or wetland. So the likelihood that this is going to be, made a through street just isn't there. It's not economically feasible. The city would never do that, or it's at least a very low likelihood that that would ever take place. Am I stating that correctly in terms of the nature of that land as it extends through past the dead end portion of the street? So that was looked into. There's nothing that there's nothing that can be done at this point in time. Those are dead end solutions. This is basically Kent's last hope in terms of continuing what he's been doing now for decades, and that's what we're asking the board for variance.
You have anything further, Mr. Beveridge, regarding his rebuttal? Ron Morelli?
Just one comment. Attorney Ellison said, I might be paraphrasing here slightly, that if every single time a vehicle comes into the lot, you have to maneuver several vehicles, that would constitute an unreasonable burden. I would agree with that statement. If every single time a vehicle came into the lot, you had to maneuver several vehicles, that would be very burdensome. I don't think we've seen any evidence whatsoever to suggest that that is the case if the setbacks are complied with. If you look at the photos we saw, you look at the video we saw, I mean, we saw a truck with a plow on it backing out with, in my view, ample clearances to everything around it. The existing zoning requirement site plan shows gaps of 29 feet, 40 feet, 45 feet, 48 feet. Just in my own common experience of maneuvering vehicles, and I've driven a delivery truck for Best Buy for a couple of years, like we had to go down some tight spaces with that thing. That seems to me like ample room. Certainly not every single time a vehicle comes in, you're gonna have to shuffle a bunch of stuff around. Now, if at certain moments in the year, at the times of the most exceptionally high congestion on the lot, you end up having to shuffle the deck a little bit. Yeah, that's part and parcel with any business. When you have the highest levels of congestion, you're going to have to, you're going to have to do a little extra work to make do with it. But I think the characterization of every single time it coming in, and I hate to sound like a broken record, I think that we just haven't seen any evidence to suggest that that's anywhere near the case here.
I also wanted to make one comment, if I may, in regards to the property and the zoning code relief that's provided via the conditional use permit. Again, to put things into perspective, a few months ago, we had another applicant that applied for a reduced setback because they were bordered by 3 streets, both Gilkay, Dixon, and Minnesota Avenue, and that was ultimately granted by the Common Council. So they certainly do exist, and again, that relief was sufficient for that applicant in this, with again, the 3 streets bordering the property.
And they were granted the same 10-foot setbacks?
Correct.
Okay.
Yes, correct.
Did you have something?
Oh, no, so you're gonna wanna ask questions now, open it up for questions now, and then deliberate?
Yeah, well, that was between them now for the board. Question from board members.
The use, was it the same use, current use we're discussing?
The one that I just referenced?
Yes.
The one I just referenced was for storage use, kind of mini warehouse storage.
Let me start on this end this week. George, do you have any questions? Either. Jim?
The only question I had, and you answered half of it, when did you start the truck rentals? The carports have been up for 20 years,
About 25.
25?
Truck rentals, it's gotta be close to 20, a little over
Okay.
20.
All right,
It was U-Haul before Penske, but
sure. Yeah,
one
gotcha.
form or another.
Right, thank you.
Which, Lynn?
Did you, yeah?
I have several questions.
Well, I'm going down the line
You're
here.
going, okay. Thinking of public safety, a lot of these Penske trucks are rented by I could literally, even though I have no experience, I can rent one, driving a big truck. Okay. Do those same people that have limited experience driving vehicles of that size park them in your facility, your parking area?
Yes.
Okay. From a public safety concern, if someone's walking on the sidewalk and you have an inexperienced person backing it in or whatnot, you know, it feels a little, it makes me feel uneasy in terms of public safety. I don't know if we can go back into the agreement that was negotiated starting on page 15, but it feels like there's a disconnect in terms of you received, or stated, Mr. Warzella, that you received, it must have been a verbal promise that your carports could go back.
That was what was discussed, because they were model ports, they could go back on the zero lot line. Accessory buildings, there were four buildings at the time, 3 model ports and 1 accessory building. The accessory building was torn down and removed.
Okay.
The model ports were coming back.
And in here, it looked like you did have an attorney representing you, at least part of the fees were during that process.
Correct.
Logan, were you a part of that process?
Yes.
In terms of, I mean, do you have any comment on Mr. Warzella's claim about the carports being verbally promised to be?
He wasn't there at the time.
Okay,
My alderman, Mike Weeza, at the time, is the one who had told me this.
okay,
And kind of how I got myself in a little bit of trouble here.
okay,
I was trying to work things out and thought that I could handle it on my own. This
Okay.
variance process and getting the 10 feet and those things there were ill-advised by city people telling me which way to go. And once I realized I was in deep trouble and this was going in an area I was not knowledgeable of, is when I had to seek counsel. And now I'm trying to backpedal to get out of what I'm trying to get done here. I agree with you on the safety issues. Originally, there was supposed to be 7 feet of grass, 5 feet of sidewalk, 5 feet of grass as a buffer. The city ended up pushing the sidewalk up to 1 foot off the line, that wasn't my doing. I didn't want that sidewalk there at all, and I fought really hard not to get it for all these safety issues. I would like to see a buffer in between there, but I would also like to see the sidewalk be moved back down to match exactly what's across the street. There's 3 feet of grass, 5 feet of sidewalk. If this goes through, I'm gonna have 22 feet of grass.
That's already been covered.
Yeah.
I don't want to.
I know, I guess, coming into looking at the hardship piece, I know I had asked, and Mrs. Borzella had explained what the revenue was. But revenue, and I don't know if it's a high margin or low margin business, and I would imagine others don't either. I see your business, from my perception, in 3 pieces. You have the rental truck business, you have the repair and tow business, and you have the carports.
And snow plows.
And the snow plows could be a 4th piece. But I think what the 2 pieces, at least from what I could understand from your testimony, that would potentially have to not operate in the same way are the carports and the Penske piece. So I would like a little bit more quantification, and I understand numbers if you don't have that, but if you could tell me what % of your profits come from, of your business, come from the rental trucks versus the canopies.
That's outside the purview of.
It is, okay.
Unfortunately, financial hardship is not one of the factors that you can consider as a substantial hardship for a variance.
Okay, sorry.
No, that's okay.
And quick question, I know you said the volumes of the Penske trucks can ebb and flow. Are there ever situations where you have more Penske trucks on your, in your care than you have spots for on your lot? And where do the excess trucks go in that case?
Up the street.
Yes, there are a great number of trucks that show up spotted through the weekend when they come in. As we see them, when we're monitoring the lot, we can move them back into my storage pen area or to the back of the shop. To a certain extent of leaving doors open for wreckers to get out and navigating the lot.
Okay. That's all I have.
Which I won't be able to put them there if I have to honor this, what they're asking. I wouldn't be able to put them there anymore, because I need to move them all forward now.
Okay.
So it would not be functional anymore if I have to comply. I wouldn't know what to do with the trucks.
Could
Ish.
I ask, picking up off of one of the questions you asked? When you said that people return their Penske trucks, and she asked if they park them. I've rented trucks, I pull it in the lot and get out and leave the keys, but I don't park the truck. So I want a clarification on that. Do they actually park the truck, or do they just put it there and you guys park the truck?
Both. I have the lot nicely paved. We sealed it every 5 years, painted nice striped lines to indicate the parking for them. And when people rent the trucks, we instruct them where they should put them when they come back.
Okay.
Some people do.
So
Some
they'd
people don't,
be
they end up all
backing
over.
this truck up into that spot?
No. When you
Pulling
enter
forward.
off of Second, you can pull straight in.
Okay,
into the store.
all right.
It's a drive-through.
Okay, because I
access.
wanted to get, in my own head, a determination of what kind of safety issue we're talking about. If it's backing up, it's an issue.
Yep.
If it's not, then.
It's a drive-through. Been doing it for, like I say, the 25 years, hasn't ever been an issue.
Ish.
Yeah, my question has to do with safety,
Okay?
which seems to be the main concern. It looks like from the sidewalk to the line where you're requesting for the variance is about 1.5 feet,
1.5 feet
1.5 feet, right?
property
No,
line.
the variance is going parallel with the sidewalk, not into the sidewalk. The distance will stay the same
But the gap would be 1.5 feet.
From the property
From
line
the
to the
property
sidewalk.
line to
it's
sidewalk.
1.5 feet.
That is correct.
That's what it's going to be, right?
And it is now regardless.
Yes, regardless of what happens, it's going to be 1.5 feet. And on average, how many people will you say, or kids, use that sidewalk? Because there seems to be some concern of traffic on the sidewalk. Can you just estimate the volume? I mean, not a hard figure, but
That's a really good question. I'm glad you asked it. There are far less children and children with parents that use that sidewalk than cut through the middle of the lot. They don't use the sidewalk. It's shorter to cut through the lot. That's where everyone goes. Right through.
thank you.
Lynn, do
I
you have any
just
questions?
add an observation. My questions have been answered. But I drive through there picking up kids, dropping off kids. After school, I typically see a group of around 10 kids that are trying to get across Second there.
It's kind of hard to see on the diagram. Access from Second Street, now, access from First Street, you don't have an apron there. But from Second Street, there's a curb that runs down Second Street. All right? How many access points do you have? How many curb cuts are there? You know?
Where?
Cur-
On Second?
On Second
To
Street,
enter my lot?
to enter your lot,
I believe 2.
okay. Were those curb cuts put in by the city, or did you put them
Correct.
in?
Yeah, about 5 years before the condemnation and the widening of Maria, they had gone through and redid Second. That was all the city's doing.
Okay. That's all I have. If there are no further, did you have any questions?
I'm okay, thank you though.
Dean?
I would comment, Mr. Chair, that I think you need to decide, you as a board, as to how you want to proceed. I do think you should give consideration to having a separate session of just the board in closed session with council to answer any questions that you may have.
Okay. That's a suggestion. I had requested that we go in and put closed sessions on agenda. I was overridden overruled by someone.
Well, I believe my advice was I didn't think that it was in compliance with Chapter 19 to have a boilerplate provision on every agenda that says the board can enter closed session if it feels the need. It would need to be a specific item listed on that particular agenda.
So we could go into closed session and discuss the matter, but then you would vote in open session.
Yeah. What's the preference of the board? We could do that, but we wouldn't be able to do it today.
The agenda hasn't been noticed properly to do that, so
I
you, yes.
understand that.
So we would need to do, if you wanted to do that, we would need to do it a different day.
It would have to be a different day.
Absolutely.
But I don't know what the board wants to do.
Well, yeah, and that's why I'm asking, what's the
I would like to
preference
make a
of the board?
motion to go into.
No, hold, let's get everybody's opinion first. We'll just see
You
if we.
can't go into closed session now.
No, we can't go into
No,
closed
I
session.
wasn't gonna say that, but propose a,
But I want to see what the consensus is the consensus preference of the board members to adjourn today and have another meeting, and at which time we would go into closed session and then come back into open session for a final decision. What's everybody's schedules? I don't know what everyone's schedules are.
My understanding, based on a case from 1993, State Ex Rel Hodges versus Turtle Lake, is that a BOA cannot go into closed session unless it's for future litigation. That they cannot go into closed session, that you don't have opposing parties in simply deciding an application for a variance or an administrative appeal.
you would go into closed session under 1985 1A, which is deliberating. You have the right to go into closed session to deliberate regarding any action that you've had a quasi judicial hearing on, which is clearly what you've had here today and at your prior meeting. Again, my advice is that you would have you would make your final decision in open session.
So my question of the board members, council's advice is that we adjourn today and reconvene, then go into close at some point in the future. And yeah, Kyle.
I would just question what are the benefits or what is the value of this board going into closed session? What would be discussed potentially in closed session that wouldn't be able to be discussed now today?
It would give them an opportunity to ask all of the legal questions that I'm sure that people have in an open and in a frank forum.
It's just a suggestion. If the board feels they want to take action,
We're absolutely able to answer legal questions in open session if you would prefer that we do it that way. Whatever the board's preference is, I am comfortable with.
So, what's the preference of the members of the board? George?
I would say we have, just like before, they've gone over this stuff time and time again since July. You got a lot of people spent their money, spent their time to be here. Beautiful presentation by litigants. If you don't have the information now, I don't see how we can postpone this again and get anything more except to go round and round and round, and it just keeps going back to that. We gotta vote on the variance issue, not on the eminent domain, not on what happened here or there. It's black and white right in front of you.
Okay.
Either it's
So
to
your preference
deny
is-
or to
is
allow.
to-
I say vote now.
I would agree.
Yeah.
Vote no.
You agree?
I would prefer to go in closed session.
Ish?
I prefer closed session.
I
Isn't
prefer
it?
open session.
And I would prefer open session also, so.
Okay.
Consensus-wise, I think we'll stay with it. That appears that testimony is concluded. I will therefore close testimony, bring it back to the board. As a reminder, we are going into deliberations now, and Jim, you'll just thoughts, deliberating, comments. George, what are your thoughts
My
right
thoughts
now?
are, I would make a motion to deny the variance request.
Okay, well, I'm not prepared for a motion quite yet, but your motion would, or you're thinking in that direction. I believe, based upon testimony, that it's a situation where, yes, there may in fact be a hardship. However, I feel that based upon the fact that the business began as apparently an auto repair and towing, it morphed at some point in time into U-Haul rentals, snowplow sales and installations, apparently. Accessory buildings, fleet truck rentals, fleet truck repairs. I think it's a case of trying to put 10 pounds of potatoes in a 5-pound bag, quite frankly.
It all worked before this.
And the owner went with counsel into the decision to sell 10 feet by 80 or 81 feet to the city of Stevens Point. They were reimbursed for the loss of land. and acknowledged in the sales agreement that the accessory buildings were going to have to be moved. Went through the Plan Commission and Common Council, and were granted a conditional use permit. That conditional use permit was accepted, may not have been joyously accepted, however, it was accepted by the owner. And then subsequently came to this board and requested that the board make adjustments or changes to the conditional use permit. I don't feel that, I feel that a hardship, if a hardship exists, was not a function of the uniqueness of the property. However, rather it's the actions by the owner that created this hardship. That's my feelings. Lynn? You have any comments? And again, we're not ready for a motion yet. I just want to see where we are census-wise.
I mean, from a public safety perspective, I am not comfortable with the south side being 0 foot. However, with First Street, you know, I'm kind of torn. But I know that's not the motion, or would likely be the, maybe it would be the motion on the table. And I understand that businesses do grow and expand, and, you know, sometimes the space they're in, it doesn't accommodate their growth. So, but I don't know if that really warrants for a variance. Otherwise, we would be meeting every month, as people asking us for variances. So, that's where I'm at right now.
Ish.
I mean, based on the testimony, the materials I've read, seems to me like the owner has really tried to work with the city to meet them. You know, he's taking some upfront costs to, you know, redesign. So he's trying to make it work, but we have the ordinance which requires something else. So, and that's where we're at, and that's my comment.
Based on the multiple uses on this property that have, the number of uses have increased over time, I feel that that's not, the fact that it doesn't all fit now as you would like it to fit, that's not hardship, that's a personal preference or personal convenience. I also have concerns about public safety by taking it from a 25-foot setback to a 0-foot setback. And I note that there's already been a reduction in the setback on Maria.
So, any motion that we make, I'd like us to concentrate on the requirements of the statute in discussing any motion. And again, this was mentioned earlier, contrary to public, not contrary to public interest, owning to special conditions, a literal enforcement of the provisions of the ordinance will result in practical difficulty or unnecessary hardship. So the spirit of the ordinance shall be observed, public safety and welfare secured, and substantial justice done. And I'd like to concentrate on those issues and also on
the portion of the statute that requires that in all circumstances, the property owner bears the burden of proving unnecessary hardship based on conditions unique to the property rather than conditions personal to the owner, to the property owner. And that unnecessary hardship was not created by the property owner. Anyone prepared to make a motion? I will then, no?
Can I just clarify something? Will the board be making separate determinations as to each of the three requests, or are you going to address them all?
What three requests, sir?
The parking, the 5-foot variance for the parking on the east and west sides, and then the 0 lot line on the southern
I don't
boundary.
think it would be done individually.
I don't believe it'll be done individually. There's a possibility that it might be a motion by a member of the board for one of the items, but I would believe that it would be just a general motion, either to affirm or deny the request.
Thank you.
It's one application.
Hmm?
It's one application.
Yeah, it's a single application, so, and all those requests were in that single application. Nobody, I will then move to deny the request of Kent Warzella doing businesses, Warzella, or Kent's Service and Towing. Neither request, the variance request, based upon the following the conditions are not necessarily special or unique to that property. There are other properties in the city of Stevens Point that have constrained areas to work with, specifically businesses that are zone B4. There appears to be a hardship, but that hardship is I find is self-created. The spirit of the ordinance is to maintain public safety and welfare and to allow vehicles and/or structures to, number one, obscure the required vision triangle, which is 20 feet laterally, east and west, north and south, would contribute, I think, to a safety concern. Additionally, vehicle traffic close to that sidewalk would be potentially dangerous for pedestrians on the sidewalk, considering the fact that there is a grammar school just to the west of the subject property. I feel a substantial justice has been done in that the applicant was reimbursed or compensated for the property that was lost. He was aware with the settlement agreement that the structures would have to be moved. He was represented by legal counsel during the sale of the property to the city. And the
added items that have been added to the property, i.e. the fact that it began as a auto repair shop and towing and has morphed into truck rentals, snowplow sales, fleet maintenance, fleet truck maintenance sale, or fleet truck maintenance, and the sale and display of carports and temporary buildings and structures, has created a self-imposed hardship, if a hardship does in fact exist. It's just, the lot was not, I don't believe, intended for that much. However, that's the decision that the owner made. So that was my motion to deny. That's my rationale for the motion. Is there a second?
Second.
Second by Mr. Dockstetter. Discussion from members of the board? Oh, no? Any discussion? No. In which case, a call for roll call vote.
I would advise that you do it as I'm a party to the case.
Okay, well, I or Maria could,
Either or.
well, I can, huh?
Either you or, yeah.
Maria, do you have the names of you've got the names?
Maria?
Go ahead. Bob, go ahead. Just-
Yes. If the secretary, please call the roll.
No.
She doesn't have a microphone.
She have the information.
Oh, she
Go
doesn't
ahead.
have it.
Go
She
ahead,
doesn't have
Bob, you do it.
Okay. Then, the motion is to deny. It was seconded by Mr. Dockstetter. Roll call vote. Ms. Markham?
Aye.
Aye. Markham votes aye.
She shouldn't. All right.
Odugba?
And Bob-
Yeah, she goes.
Odugba?
Nay.
No. Odugba votes no. Schulist?
Aye.
Schulist votes aye. Dockstetter?
Aye.
Dockstetter votes aye. And Weir votes aye. That's 4-1. The one no vote was Mr. Odugba. Okay. That concludes the hearing in that case. We do have one additional item on the agenda, and that is for a discussion which Ms. Markham asked for at last meeting. Discussion of the appeals guidelines and procedures. So, go for it.
Sure. So there are two short portions of what's on page 73 of our packet that I'd like to bring up. The procedure guidelines.
Thank you, board, for your time.
Okay?
Thank you.
Thank you.
Thank you, Kurt.
The first is near the end of the paragraph that starts preparation prior to the meeting, where it says all agendas will contain appropriate notice that the board may at any time adjourn into closed session in accordance with 1985 1A to deliberate at a quasi-judicial hearing. When I read 19.85 1A, it says deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. My understanding of a case, the definition of a case, is that you need to have opposing parties to have a case. And the the court case that I referenced earlier, this Turtle Lake, Hodge versus Turtle Lake. My understanding is that having an applicant applying for a variance, applying for an administrative appeal, that you don't have opposing parties in that situation. You simply have an applicant applying for a variance or an administrative appeal. There is another part in 1985, the exceptions that allow you to go into closed session, 1985 1G, that's conferring with legal counsel with respect to litigation. I think that's a very valid reason for a Board of Appeals to go into closed session.
Okay. Opposing parties. At least in my 20 years here, we have an opposing party. You have the applicant. The applicant would not be applying for a variance unless the zoning administrator says you can't do it that way. Right? So there is always going to be opposing parties.
I've always
don't- you
viewed
don't-
those
you don't
as an
go to-
applicant and an administrator.
Pardon?
I said I've always viewed those as an applicant and an administrator. In some cases, the administrator may choose to recommend that the standards for a variance have been met, in which case they're not opposing.
But that would then impeach, I mean, it would be like an assessor saying, well, yeah, you could change the assessment on this property. I think I assessed them too high. The assessor's impeached himself then, okay? And the zoning administrator, his duty is to enforce the zoning code.
Correct.
Okay? If he were to come to this board and say, yeah, let this guy, give him a variance, then there's no sense in us doing it, and counsel, you go ahead.
Us having moved on from the previous item, I think I can certainly advise the board here on this one. Got the case pulled up, and I think that there's an important distinction here that kind of explains everything. In that case, this Turtle Lake case, it was a permit application for a permit to store junked automobiles, and that was being considered by the town board. And in that type of scenario, I think you're right, there's not an adversarial matter going on. That's not even a quasi-judicial
Yeah,
matter.
just, it's not a quasi-judicial.
Right.
Yeah, it's not quite as it is.
An opinion written by Stevens Point's own Bill Bablich. So, and moreover, though, I think in that case, also, the particular part of 1985 that a board invokes matters, obviously. And even if a situation lends itself to a use of one of those categories for closed session, if you invoke the incorrect one, you can invalidate that closed session.
Oh, yeah,
So there, I think they could have, if they would have had everything noticed appropriately, they could have gone into closed session to confer with legal counsel for a matter that could, become litigation. If they're saying, we're thinking about denying this permit, but we don't know if we have solid legal ground on which to do so. However, they used 1985 1A, which in that context was inappropriate. So the court probably didn't even answer whether or not the 1E exception could have applied. They probably weren't being asked to answer that. But I think with regards to the matters that are heard by this board, 1985 1A would be the most appropriate. However, I think that with regards to actually carrying that out, it would need to be not sort of a disclaimer at the bottom of each agenda, no matter what appears on it. It would need to be something that, item number 2, consideration of a variance request by so-and-so. Item number 3, enter into closed session for deliberation with legal counsel with regards to item number 2. And I think that would be the best way to do it.
And you refer to A, you refer to one.
Right,
Right.
1A.
Wouldn't
Right,
1E work
1A.
too?
What?
Wouldn't 1E work too?
No,
You don't think
You know,
so?
Clearly, in a case like this, you're deliberating,
Yeah,
that's
that's true.
1A, and you gotta be specific to
Okay.
the purpose for which you're adjourning into closed session.
I think you could make an argument that 1E could apply. I
could get
mean,
sued.
litigation, you could be sued,
For making it,
as we've seen.
that's another case.
But I always go with the one that's the most
There has to be a
on point.
reasonable expectation.
Okay.
Right, that's
Litigation,
true.
You're right, Dean. I apologize.
So how do you measure that? A reasonable expectation of litigation?
At the stage that you're trying to decide what your decision should be, you can't make a reasonable projection whether somebody's going to challenge it because you don't know what your decision is yet.
That's right.
So it's really a 1A deliberation. Adjournment.
So I think my bigger concern is transparency for the applicants, for anyone else who wants to come to a hearing and listen to the evidence presented as well as the deliberation.
Well, you've done that here, and you've shown you can do that, and that's fine. Here is the reason why I made this suggestion, and here's why I have the concern. It is very hard for me to sit as legal counsel for the Zoning Board of Appeals and render advice in public. I frankly don't think I'm doing much value at all for a board if I'm rendering legal advice on interpretations of state law and your zoning ordinance in open session. That's what your parties have both done, and you should be calling upon Ms. Dykeman and myself to say, okay, there's been these interpretations, what is our interpretation, or how do we view their legal arguments? You've shown you can do it, you don't have to go into closed
Right.
session.
But then there's the
It's very hard
attorney-client
for me to give
privilege as
advice.
well, that you're
So the,
using in public.
correct, because if.
You'd be waiving
you,
it.
you would be waiving it because you would be permitting other people to be in the
Exactly.
session, and that is a waiver of your attorney-client privilege.
Exactly.
Yeah, and if I were advising the board in closed session as to, the deliberations, I'd be saying if you were to decide this way, here are the greatest points of weakness you'd be exposing that decision to. If you were to decide the other way, here's the greatest points of weakness you'd be exposing that decision to. And I'd be trying to evaluate the likelihood, A, that somebody would seek judicial review of it, and B, what the likelihood of their success in that would be.
And that's
You don't
not
want to
good
hand
advice.
that right to the party, no matter what decision
No,
is made.
exactly.
So,
You don't want to do
All right.
that.
Exactly. You
But I
have your-
think that you can, in open session, clarify your understanding
Well, yeah.
of the law, of statute, of
But-
case law.
It gives the board certain protection, particularly when you're addressing the strengths and weaknesses of approving or denying an application. First of all, because you're waiving your attorney-client privilege, and second, because, as Logan said, you'd be handing the case to somebody.
And I think that the transparency aspect you're talking about is very important, but I think that the time and manner in which to provide that would be when you come out of the closed session. It's the comments that are made publicly by the board members in terms of their findings, those findings at that point having been well-informed by the legal advice that was given in closed session. You say, all right, we've consulted with our attorney, we've reviewed evidence, and here's what we think. And then you run through basically what accompanied Bob's motion.
Yeah.
That sort of explanation, which here was, I wrote a whole page of notes based on that, and I think that, he made good reference, well, we shouldn't be talking about that one, that's
No, it's passed.
But,
past, and it's, but,
and then, and you're aware of the reason that I put that into the procedure document.
right,
Because, we've had situations in the past where, it was like ping pong. With people in the audience, making comments and so forth during the, and as a matter of fact, if you listen to the entire tape from the July meeting, you heard it. So what I'd like to do in the future then, just leave it in the procedure manual. But when the agenda is done, rather than a boilerplate notice
Right.
to notice, we'll put it in there every time that we may go into closed session.
And when you get to the item for the closed session, you can vote not to, or
Right.
somebody can say, I'm gonna move not to go into
Right,
closed session.
right.
Exactly, because I think we're.
You know, because we aren't always gonna be represented by council either. Okay? There are,
No, because I
some,
think other cases, Logan, you're gonna be representing us, correct?
in some
My
cases.
intent is to ensure that there's always representation of the board. Now, it may not always be me.
Yeah.
I think most of the time, it's gonna be the zoning administrator all on his own.
Yeah. Well, you know, and again, that's the reason I wrote it in there too, that once I have a feel for what the case is, and, you know, it's not ex parte communication necessarily, it's just that Kyle tells me, okay, we have this, you know, case coming up in 2 weeks, and the applicant was so-and-so. And I said, oh, geez, he's got money, he's probably gonna have a lawyer. Okay, so then I will request that if the applicant is being represented by counsel, i.e. the application comes in and it's filled out by an attorney, I'm almost certain that there's gonna be an attorney representing the applicant. And that almost certainly you or somebody is gonna be representing Kyle. Okay, in those cases, then I, as the chair, am gonna request that the city provide counsel for the board. Because I don't wanna get caught in the middle of, you know, what John Gardner had back in July, where you had two attorneys arguing back and forth. And I, as a member of the board at the time, asked the question, you know, what's the authority? You know, do we have the authority to grant a variance from a conditional use permit? Well, I know the answer now because I have two attorneys
Right.
that we had coffee with.
And I can tell you with certainty that the question will never be, is the board going to have legal counsel? The question in any given one will be, is there going to be legal counsel assisting the zoning administrator in presenting the case? He's every bit the expert on this type of material
I know
that I am.
I know the code quite well,
Yeah,
so.
he-
In
You've
most-
demonstrated that
in
numerous
most cases,
times.
he will represent the board.
Right.
I will just represent myself.
Probably the most difficult thing there would be if there was a matter where Kyle was deliberating on whether or not legal counsel was needed on behalf of the zoning administrator. He wouldn't want to come to me to ask about that because it could end up creating an ex parte communication that way. So that's a discussion that probably would be better for you and I and Michael to have in a generic sense in terms of establishing some policy perhaps, but there's always going to be counsel for the board. I'm not going to let that situation happen again where you're in here without counsel. That was an oversight.
Well, thank you, sir. I might even vote for you next time you come up for election. Lynn, did you have you had another item you said?
I
There were
do,
two things?
and it's also related to the transparency thing. Both transparency as well as encouraging public participation. So in the next paragraph that's labeled meeting sequence, it says all meetings of the board will be open to the public but are not public hearings. So I went back to the statute and I see in the city statute, you know, it says that zoning boards hold hearings. It doesn't say they hold public hearings. My concern,
Are you speaking of the city ordinance 23.05?
right. I am
Okay,
speaking of the city
That thing
ordinance.
was written in 1979. Do you realize that?
I didn't know what year it was written. So, my, I guess, goal, and I think it says that the applicant can call witnesses, the aggrieved individual party may call witnesses. I can see both sides of this, that most people who come to attend a zoning board hearing don't have a legal background in zoning boards and how they make their decisions. So most of their comments are, I'm fine with what my neighbor wants to do, or I think it's terrible because blah, 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 whatever their reasons are. They're not tied to the legal
And they're
standards
more
that we
emotional.
need to use.
Usually they're emotional.
However, I do think they have a right to say their piece, and if they choose to become informed about the variance standards, to then frame their comments into whether they feel there's a hardship or, you know, an impact on the public interest. So I'm uncomfortable with saying, for instance, if an applicant, whoever the applicant is, says, well, so-and-so is my witness, and so I want to call them to the stand, and they provide testimony that they're fine with whatever the applicant is proposing, and there's another neighbor sitting in the audience that the applicant chooses not to call on as a witness, and they get to provide zero input, I think that's unfair.
Well, you know, I mean, I don't intend to, you know, tell them, give us a list of your witnesses or, you know.
Yeah.
I mean, if somebody raises their hand
Uh-huh.
and it's during the applicant's portion of the meeting, I'll ask them, do you want that person to talk? You know, I don't care, you know, but I don't want to get back into what we have, and again, Logan can affirm this, you know, what we have had in the past where people get up there and say, well, yeah, he's a great guy. Okay? I want the testimony to be keyed toward 6223-7E. Okay? Tell us what you have to tell us about this particular case and this particular application.
Right.
And don't tell me about, you know, who you went to high school with.
I think that, you know, obviously relevancy is a concern. The rules of evidence in this type of format are pretty relaxed. But I think there's kind of a more fundamental principle at work here, which is that unlike other items that are heard by the various commissions, boards, council, and everything, this is a quasi-judicial proceeding. And there are parties to it. And they have a right to be able to present their case the way that they see fit. To make the comparison to like a circuit court case, you know, if I'm going to court for a family law matter, you know, something relating to custody of my children or something like that, yeah, my buddy might want me to win that case and think I'm a swell guy, but even if he has relevant testimony that he could offer, but I just don't think he presents well as a witness, I ain't gonna call him. And I have a right to not call him. You know, maybe the opposing counsel wants to, but to be able to guide and set up my own case, because it's my interest at stake, not that neighbor's or whomever. If this was a rezoning matter, something with the plan commission, it's a public hearing, anybody can come and say their piece. But here it's, you know, another one of the quasi-judicial contexts that would come up would be if somebody was having their liquor license suspended or revoked. The council sits as a judge, and we have, you know, a hearing at the council where you've got attorneys, you got parties, they can call witnesses. But, you know, the person from up the block who just doesn't like that doggone tavern, they don't get to speak unless somebody wants to call them as a witness. And it's just there to ensure that when somebody is advocating for what they believe their rights are under the law, that they're able to do that in the way that they feel is fit. Because ultimately, that person has very, very little interest in the outcome of it compared to the person who actually owns the property. So that's why, and also because you weren't on the board last summer, but
Right.
the initial time that this matter that we heard today was heard, it turned into a bit of a free-for-all, and trying to keep track of who was speaking, and it wasn't great. So that's my take on it. I think it's mostly about respecting the rights of the applicant and of the zoning administrator.
I do want to add a comment, if I may. I think what Lynn's trying to say is, does the acceptance of public speakers help to determine whether or not that the variance, if granting or not granting, will be in the public interest. Oftentimes, in the past, we would notify property owners within a 200-foot radius, staff. As a party to the case, we also would list these as a public hearing. We've now come to the realization that we don't necessarily have to list them as a public hearing, but do we still notify the property owners within a 200-foot radius? In most cases, we will, because that helps staff to answer that question as to whether or not this is within the public interest. Because in the case of a variance request a month ago, there was a neighbor who submitted a letter in regards to the granting of a structure within the setback and how they would be impacted and their parking would be impacted with the granting of that variance. Hence, then you can identify that that may be in the public interest because that neighbor is voicing their concern. In the event, however, that that neighbor did not send us that letter and decided to show up to the meeting anyways, I would not know who that person was and I may not know what their testimony was. The applicant may know their testimony and may know that they are against the case, thus not call them as a witness. So now, if you grant the variance, you have not heard that person's testimony, which may have changed the outcome of the variance because they are essentially a neighbor that is going to be directly impacted by that variance. And thus, that may have been a reason to deny the variance if it was against or determined to be against the public interest. So that's the concern I would have without allowing members of the public to speak.
See, we don't agree on everything all the time.
My take is, you're supposed to do the findings of fact, right? You're supposed to interpret the law, right? And part of one of the stipulations is to determine whether it's against or it's in line with the public interest. So you know more about the ordinance than the people giving the testimony.
Correct.
Because we rely a bit on, a lot on your findings of fact.
Sure.
So regardless of, how it impacts the personal use, like the case you mentioned just now, I think your own findings of facts carries more weight as regards the public interest than the testimony of the neighbor.
And I don't necessarily disagree with you. I think it can be handled on a case-by-case basis, though. I could, go knock on doors on these cases and try to get either verbal testimony or written testimony, but, I'm not going to spend hours and hours trying to do it because I have other duties in my job. And, it again affords that person an opportunity if I cannot reach out to them or I cannot verify whether it's harming the public interest. Because to tell you the truth, in most variance cases that I've written staff reports for, that's one of the easiest ones to meet, is that it is not going to harm the public interest. But that's primarily because I'm not knocking on doors and I'm not seeing directly how it impacts the surrounding neighbors. And because that's very difficult to measure as opposed to the other standards of review. So, I think if you afford them the opportunity to speak, you're then kind of checking off that review criteria more than you maybe would be in the finding of facts, for those reasons mentioned.
Yeah. And again, I wouldn't mind having, opening it up to the public to an extent. I don't want it to go the route that it did with Napawaki with the what's a survey, where the fence is definitely not there, it's over here, and these types of things, I don't want to go that route because, and as you stated, in July, it was a zoo.
Yeah,
in there.
burden of proof is on the applicant, and they should be calling their witnesses. If they haven't done their homework, they can't call those witnesses. If you don't, you open it up to being another open forum, common council. He who shouts loudest, last, might win, might not, but you'll be here for hours. You gotta stick to the quasi judicial thing that Logan's talking about, and it's just.
That's another one of the considerations. When you talk about hours, an applicant is sitting here with an attorney. TikTok, and that's expensive time. And if the hearing lasts an extra 90 minutes, 2 hours, because we've got comments from people who live totally on the other side of town, but just have an off-the-cuff opinion about this case, that's hundreds of dollars.
I think that based on that and what Kyle said, if they have an attorney, they went out and knocked on doors and have the people here that are gonna put quality information into their testimony.
And so in response to that then, for example, if I wanted to ask the audience members who are direct neighbors or who live within a 200-foot radius, and if those raise their hand, could I then call on them as a party to the case up to the stand to testify?
Certainly.
Okay,
Absolutely.
perfect.
Calling a witness.
Yeah.
Because
I think,
you're,
well,
you're
then I think it can be handled
yeah,
with that route.
you can call witnesses, you know.
But the magic of that is that you're tying it to somebody who's impacted.
Sure.
Or in the vicinity.
Right.
I think that's different than having somebody
Well,
from.
we can
Yeah.
handle it that way in the future. You know, I don't have any objection to, you know, you or somebody in your office, Maria, end up doing it. Sending letters out to all the property owners within 200 feet or whatever it is, and tell them about the meeting. And
I think you don't need us anymore.
Well,
Yeah,
Speaking of
it's only,
expensive lawyers.
it's only costing the city money, you know, whatever.
thank you all very much.
Hey, Bob, it's just like,
Should
you know, they
we-
want to put a chicken coop up.
Yeah.
Make a motion to adjourn.
You guys alert the neighbors.
How many chickens do I get?
Are we done? I would advise that if there's no more
Chicken.
comments on item 3, then to move on to item 4.
Agenda's exhausted.
And we are adjourned at
He's still studying.
3:52.
Yeah.
A video of this meeting is available for viewing on the city's website, stevenspoint.com/videos.